Welcome to Being Social. My name is Praveen. Today our guest is Mr. Bhanu Ilindra. He'll be talking about the updates on new policy memos. Thank you.
Being social. Over to you, Bhanu.
Yes, thank you, Praveen Garu. And you all know that my name is Bhanu Ilindra, Andy. I'm basically an immigration attorney. Our law firm name is BBI Law Group PC. We are located in Herndon, Virginia. And we exclusively practice in immigration law, Andy, basically. And we all know basically that IT Serve Alliance actually filed quite a few lawsuits against the USCIS about the itinerary memo and also about the Neufeld memo and everything, which were the basically adjudication policies by the USCIS pertaining to H1B petitions, basically, And the district courts ruled partly in favor of IT serve and basically and partly denied their benefits, basically. But however, in reality, that actually the outcome is not in favorable to the USCIS, basically. And because of that, what happened is USCIS entered into a settlement agreement with the IT Alliance, basically. And with that settlement agreement requirement is basically is that within 90 days of that agreement date, USCIS basically resigning Neufeld memo, which is basically issued in 2010 about the employer-employee relationship and other information, basically. And also about the, and also 2018 unnamed USCIS memo, which deals about the itinerary and the contract requirements basically from the employers and everything. So those two memos have been rescinded by the USCIS. Basically, courts clearly held that USCIS did not issue those memos in accordance with the law. Basically, they were in the violation of the Administrative Procedures Act and other things also, basically. Now, the effect of that, basically, what we are worried about, basically, how US is going to adjudicate the cases. Are we going to get any updates soon from the USCIS and everything and all that stuff? We are waiting on it. And the USCIS actually came this Thursday and actually issued a little policy memoranda to the US, to the public, and also to the internally for the USCIS, basically telling the officers, adjudicating officers, not to apply any more 2010 Neufeld memo and as well as 2018 itinerary and other memos, basically unnamed USS memo, which deals with the itinerary and the non-speculative employment. Basically, that's what I would say. Basically, for that reason, and in that and now, officially, now we know that those memos are no longer in force existing right now. So as per the USCIS, basically, these memos have been rescinded effectively as of June 17, 2020. So from June 17, 2020, USCIS should not adjudicate cases pursuant to these memos, basically. You may have received RFEs on the cases, pending cases, but if you respond to the RFE using this particular memoranda issued by the USCIS and explaining the reason why you still meet the requirements under the preponderance of the evidence standard, the H1B's approval, then you should be able to do that. And that's what it is basically. Now, the many questions we got after this particular memo is issued basically is how employer-employee relationship is basically considered under the new guidelines, under the existing laws, but not new guidelines, basically, under the existing laws and the policy of the USCIS and the regulations, existing laws, regulations, and the policy, adjudication policies by the USCIS. That's what they look into, basically. So USCIS, basically, in this policy memorandum, clearly said that the adjudication officers should look into any one of the factors in the definition given by the regulations, what constitutes an employer-employee relationship, basically. Previously, USCIS used to stretch on a common law definition of control and say that every employer, especially if the companies where they place their employees at the third-party client sites to show how they control on a day-to-day activities, basically. And that was a mandatory requirement, USCIS, in adjudicating cases to establish whether somebody has an employer-employee relationship or not, previously pursuant to the Neufeld memo, as well as 2018 memo. Therefore, they were forced employers to provide day-to-day activities of an employee for the entire duration of the H1B petition, basically requested. And if they cannot meet that, and if the employers cannot provide that day-to-day memorandum, basically, then what USCIS did is basically is that by looking into the evidence provided by them, and if they believe that under the preponderance of the evidence standard, if the employer meets for a certain period of time, but cannot meet for the entire duration for which they requested H1B, then they adjusted the H1B validity date and approved for the short-term approvals. That actually resulted very negatively in reality, basically, because sometimes we receive these approvals actually after the ending date of that H1B approval. For example, sometimes what happened is if they believe that beneficiary is eligible for H1B till January 2020, in April, they approved basically till January 2020. It's just an example, basically, I'm telling you. We have seen those, those kind of things also we have seen negatively and everything. Now, as per this memo, now they can't do that. They have to approve for the entire valuation of the H1B petition if you can prove employer any one factors of the definition of the employer-employee relationship explained in the regulations. I'm going to explain what is the definition is and how one can meet and all those things also in this call. After this particular brief introduction, I'm talking about basically on this call and everything. And so basically, so that's where it is being there. But however, still USA said that they can still issue short-term approval notices to the employer. However, not on the basis of the 2018 unnamed memo or a Neufeld memo, but on their own analysis and reasoning based upon the evidence provided by the employer. And if they give that short-term approval, basically they have to provide a letter in writing with explanation why such it should be warranted for the short-term period. That is basically what the USA said in this particular memorandum about the H1B approvals and everything. Now, as I said, let's go basically a little bit behind in the timeline about the history, how this particular policy has been developed by the USCIS and what made them to do and everything and all these things. Now, we know that USCIS was adjudicating H1B petitions based upon these two memos, basically, for all these years, basically. Now, these memos are not there. Now, what is the source USCIS is going to look into to adjudicate H1B petitions, basically, right? And how it's going to be, basically. Is it going to be like prior to 2009, 2010, or it's going to be a little bit different from that time to now, basically, and those factors will come into existence, and those things will come into picture. Everybody has worried about everything and all those things. USCIS in this memorandum clearly said basically that they are going to look into basically rely on the statutory and regulatory guidance, as well as basically they're going to look into the binding court precedents also and administrative appeals offices adapted and precedent decisions and current USS policy guidance concerning the H1B non-immigrant classifications. Basically, so there are different sources which they look into. First, they're going to look into the statute, which is basically Immigration and Nationality Act, and then they're going to look into the 8 CFR H1B regulations. Basically, that is basically 8 CFR regulations. 8 CFR is basically the regulations, basically, and then they're going to look into the binding court precedents. And that means if any district courts basically that have issued a decisions, basically if the USCIS basically adapts them, basically notes them as a precedent for them to adjudicate H1B petitions, those court precedents, basically. And then administrative appeals office, which is basically appellate authority of the Department of Homeland Security, that means by the USCIS basically is the administrative appeals office, and their adapted and the precedent decisions will be looking into and I'm sorry, have some technical difficulty for that. My apologies for that. And so basically they're going to look into those factors and see basically how it's going to be done. Now, it's very, very important to understand the basis for the 2010 Neufeld memo came in, basically, right? And now, basically, we all know that the Neufeld memo stretched on control factor, but the regulations actually speak about actually how one can establish an employer-employee relationship, right? The regulations clearly define how an employer can establish employer-employee relationship of an employee if the employee works at the third-party client side. Clearly, the definition is basically says that hire, pay, fire, supervise, or otherwise control. There are different factors, basically, like hire is a factor, pay is a factor, firing is a factor, supervising is a factor, or otherwise controlling the work of the beneficiary is a factor. These factors has to be reviewed independently, basically, not together, or not as an alternative to control, basically. That's what the court said, and USCIS came back and now agreed, now basically issued this policy. As per what the court directive, that's what they have to look into. They have to look into it basically is that if the employer can establish any one of the factors, hire, pay, fire, supervise, otherwise control the work of the beneficiary, then basically under the preponderance of the evidence standards, then that H1B should be approved. And also, what is the source, how an employer basically can determine or can show to the USCIS under the preponderance of the evidence standard that they are actual employer, right? The basically is providing, usually what is the information we provide to the USCIS, basically, right? Previously, because of these memos, we were forced to provide agreements, purchase orders, client letters, and all these things to establish employer-employee relationship, especially when the consultant is working at the third-party client side. Now, as per this memo, now it's not required. Now we do not have to provide any agreements among any layers in between, or between the end client or anything like that, or any purchase orders or any letters from the clients or end clients or vendors, whoever they are in, to establish employer-employee relationship. However, if employer attaches them, they can then the USCIS officers can look into them to consider, to evaluate whether their employer-employee relationship exists or not. But now officers cannot ask for those documents basically under the preponderance of the standards as per the policy after this memo issued to the after this memo has been issued and came into effect, basically. Okay, and what they said is basically is that because those requirements have been actually designed by the Neufeld memo, therefore those documents cannot be asked or demanded to determine employer-employee relationship. The USCIS can determine that relationship based upon the actual whatever documents provided by the employer, basically whether there is an employer-employee relationship exists or not. Now it becomes very simpler under the preponderance of the evidence standard what we can do for the employer. Previously, although it's a preponderance of the evidence standard, but especially with the California Service Center, we have to present evidence more than preponderance of the evidence standard. We have to provide almost meeting the requirement of clear and convincing evidence standard to provide evidence so that we can get the approvals. I'm talking maybe too many legal terms over here. I do not know whether the audience will understand that or not, but I will explain what is evidentiary standard, which I'm trying to say all the time when I'm explaining all these things. Evidentiary standard is basically is the burden of proof, what we can show to the USCIS to seek the benefit what we are seeking from the USCIS. And most of the immigration procedures have evidentiary standard is preponderance of the evidence standard, basically. What is the preponderance of the evidence standard is basically it's more likely than not. That means basically it's more likely that is basically 51% of the chance that this employer, that this particular petitioner, whoever is filing a petition may qualify as an employer, and the beneficiary for whom they're filing may qualify as an employee. There's a 51% chance then they have to approve this petition, basically. And that's what the standard is, basically. Okay, that is what preponderance of the evidence standard, and that's what I'm trying to explain when I'm explaining all these things in detail. Exactly Bhanu. What to be there, what not to be there. You know,
Bhanu, I just wanted to apologize for interrupting you. So
sure.
Basically, the audience would like to really understand the layman language. For example, you were referring to 2018 memos, right? And
yes.
ITServe filing some cases.
Yes.
Would you mind throwing some light on what were the memorandum of 2018, not in the technical terms, but how it reflects to the employees and how they can understand? So that will give more relation to 2018 and what is the change in the memo and what are the things they are facing today.
Okay, see, 2018 memo basically demanded employer basically to provide all the agreements and contracts among all the layers in between to determine whether there is an employer-employee relationship exists, especially when the consultants or the employees working at the third-party client side. We see this very common, this kind of a business relationship, which is basically, it's called C2C agreement or EVC employment model, whatever we call them. EVC is basically employer vendor client model, basically, or EC model or EVBC model. This is a very common models we see in the business, basically, especially in the IT business, basically, as well as in healthcare business. And this is more prevalent in IT consulting and than any other industry. Basically, in IT consulting industry, what happens is basically is employees actually work at the third party client side. For example, your employer A actually helps files H1B petition for you, basically saying that you're going to work for the client B or client C in a particular location, basically. And usually that's how they do that. Their business is basically is hiring you and placing you at the different client sites where they have a contractual relationship with them, basically. Okay. 2010 memo, Neufeld memo, actually issued, and basically what happened is basically is that 2010 memo basically said that it is impossible for to determine how the employment relationship exists because employer do not directly involve on a day-to-day activity of this business of the beneficiary's job duties, especially when the beneficiary is working at the third-party client side. How do we determine that actually you are the employer, not the end client who is actually the client who is actually receiving the services of the beneficiary? And that's a very valid question, basically, which they had. But regulations already define how employer-employee relationship basically exists without going through the proper procedural policies memoranda. Basically, there are certain procedures which they have to follow if they're changing substantial changes in interpretation of the law under the authority given them by the statute or by the precedents of the Supreme Court decisions and everything, basically. So they just went out and they said that in 2010 memo that in order for you to prove employer relationship, the factor which we look into is control. How do you control individual job duties, basically? And for that purpose, what you can do is basically is that you can provide agreements, contracts, or letters, or anything like that, basically. Okay. And if you provide any one of those documents, and if those documents under the preponderance of the evidence to standard basically shows that you qualify as an employer, and we will approve this H1B petition, provided that petition, the position which you are filing qualifies as a specialty occupation, basically, right? And under those circumstances, basically what happened, then new thing has developed, basically saying the client letters, basically. In the client letters, employers is to get a client letters showing that they are the actual employers. They are the ones who actually control the beneficiary's job. Therefore, this H1B must be approved. They are just the clients, they're using their services of them pursuant to their agreement with the employer. We used to provide these client letters in the past. Just providing the client letters, we used to get the approvals and everything.
So, but does that mean
yes,
that?
Sir.
So you made it one point that today with this memo we need not provide any client letters, SOWs, or a message. So yes. Does that mean it's a good news for all of us that the extension will happen 2 years as per the norms, or still they will be evaluating, or they will be coming for auditing whether the person is working or not? So how does the decision still impacts?
The decision impacts is basically, as you said, the good thing is now you do not have to provide those documents, basically. Mm-hmm. Like for example, the H1B program actually works through the attestation program. It's an attestation program. Basically, the H1B petition requires employer attestations under the penalty of perjury, basically saying that whatever the information is providing in the H1B petition is true and correct, and there are no intentional misrepresentation of the facts. Okay, if the employer in the H1B petitions provides where the consultant is going to work and who's the client, who's the project, what is the terms and the condition of the contract, and if the employer with the documents is providing establishes any one of the factor like hire, fire, pay, supervise, or otherwise control of the work, then USA should not ask for any additional information. So it's a good news to such an extent. Okay, but the bad news to other extent is basically is that USA still said that basically that although they don't require these agreements, these policies and everything, they still look into the precedent decisions, basically, right? And what are the precedent decisions which are really in prominent with H1B regulations as of now is there are two cases, basically, very, very prominent as of now. One is Defensa versus Meisner, which is basically a Fifth Circuit Court case, which has been decided in 2009, basically. Okay, that has been adapted as a precedent decision in 2009. Actually, that is the decision is basis for the Neufeld memo that came in 2010, because that decision basically the court basically said that because the employee works at the third-party client side, you don't do anything for the employee on a day-to-day basis. We do not know whether you control the work of the beneficiary or not. Therefore, employee actually deemed the employee of the client, but not yours. Therefore, you're not eligible. However, Defense versus Meissner forgot to basically explain who actually petitioned H1B petition, basically, right? And because when they adopted the decision, when they drafted the Neufeld memo, USCIS really went on murky. They made it really murky about the employer-employee definition, basically. The statute clearly tells that who can file H1B petitions in general, basically. We need to understand that in the beginning. The employee H1B petitions can be filed either by employers or by their agents, basically. Okay. And when you file an agent, basically, as an agent, you have to establish that your principal and agent relationship, contractor relationship exists, and you have to provide definite itinerary for the employee as per the statute. That means where the employee is going to work, what is he going to do for the entire duration for which you're asking for H1B petition, basically. Defense versus Meissner did not address that issue, basically, because that issue was not basically fought by either party, saying that they qualify as an agent or anything like that. Okay. Therefore, they did not address that issue. And because they did not address that issue, USCIS, when adapting this decision as a precedent, basically, when they drafted the memo based upon that, they completely forgot about the agent part, basically. They basically, one way or other, if you look into the Neufeld memo, it basically forces you to prove whether you're an employer or not. If you prove as an agent, doesn't matter. They will not approve the case, basically. They strongly believe that agent petitions only comes for the fashion models or anything like that, not for the H1Bs, for the specialty occupation workers, just like a computer engineer or software engineer or something like that, basically. Okay, or a doctor or a healthcare nurse, basically a physician or physical therapist or anything like that, basically, right? So that factor is basically completely forgotten by people. So now, because this memo has been taken off right now, and that is what that memo is, basically, right? And then what happened is, with that memo, people are basically sending the client letters and all these things. And they've seen there are a lot of issues with the client letters. Genuinity of the client letters has come into picture, whether they are really genuine or not is a factor which is coming into existence, basically. Therefore, what happened is California Service Center went a little bit more abroad. And basically, they're saying that just client letter is not enough. You have to provide agreements and the purchase orders and all those things also among any layers involved in between. For example, if you have an employer and if you have a vendor 1, vendor 2, vendor 3, you have to provide documents between all these layers and the client, and between the client and the vendors, all those documents, basically. In 2018, unnamed memo actually requires an employer to provide that. They provide that you have to provide every document between the clients and agreements, basically, in order for you to establish employer-employee relationship. And also, not only that, what that memo said that is basically is that if a 2018 memo said that is basically, if the employee works at a different site locations, not at one location, but in a multiple site locations, then you have to provide non-speculative day-to-day itinerary, definite itinerary, basically showing that how, where, what are the dates, employees going to work in a different site, this site, that site, and everything, basically. You have to provide exact day-to-day. This day is going to do this, is going to do this, is going to do this, is going to do that. That's what the memo demanded, basically. Okay. And that is basically practically impossible for the employers because, as I said, sometimes this responsibility can be shared by an employer and by the client. For example, employer has an authority to place whom to place at the client side and what to pay him and when to pay him, whether to, how to supervise, how to assign the job, how to assign, and all those things. But the end client is the one who actually wants the product to be developed for him, basically, right? What kind of a product he wants to be developed, whether it's an healthcare services or it's an IT services, basically, right? Depending upon that, basically, right? So they may control exactly the requirement providing, basically, right? For example, end client may provide requirements saying these are our requirements and this is what you guys have to do for us. This is what you guys have to develop. How you do it, how you So they share the responsibilities in reality, basically, So it's impossible for an employer to provide exactly for the entire duration. And also these contracts, most of these contracts are ongoing. They're never ending, basically, right? And sometimes there could be various reasons. Sometimes they go for 4 years, 5 years, sometimes, or sometimes they abruptly cut because of the budget changes or a policy changes, or basically entire business model as of the employer who's actually filing an H1B petition in reality, basically, right? And that is actually a problematic with this memo. And also, there is no legal authority for the USCIS to issue this memo. Statute or a Congress never intended to do this. And also, because it's a substantial change in law, they have to follow Administrative Procedures Act to issue this kind of a memo, which USCIS did not do that. What is that basically requires? Notice and comment rule processing. They have to comply with that if they're trying to make any substantial changes in law or interpretation of law, basically. Okay. It is basically, these policy memos are basically nothing but interpretation of the statute, interpretation of the law, which is basically, and also substantial changes in how to adjudicate the interpretations. And that's why this is the argument made by the IT Server Alliance in those cases. And the courts actually agreed with the IT Server Alliance and their lawyers and basically said that, yes, these memos did not comply with the statutory requirements, that is basically Administrative Procedures Act requirements, failed to contain with the notice and comment. And also basically not only talking about the procedural aspect, they went also discussing about the actual substantial change of the law, whether that kind of interpretation is required or intended by the Congress or not, basically, or by the statute requires that kind of as given such kind of a difference to the USCIS under the matter of Kisor and other case laws, basically, which is basically very technical. I do not know whether ordinary audience will be able to understand that when I'm talking about in this call or not, basically,
Yes.
And that's why these memos have become so complicated, and it's almost impossible for the employers to meet certain times the preponderance of the evidence standard because of these memos. It has become so much difficult, so much burdensome for the companies and everything. Now these memos have been taken off. Now they have to go back and they have to start looking into the regulations. They have to start looking into the statute and precedent decisions and then adjudicate the cases. Okay. So now, if I were your attorney, I would say that when I file a H1B petition, I will not include any agreements, any purchase orders, any client letters. It's good we have them. It's good we have that information, but I don't see the necessity to submit them unless USCIS issues an RFE and asks us an RFE, and basically depending upon how the RFE is basically shaped up and how the issues have been framed, based upon that we'll provide that information. If I were your attorney, that's what I will do. Of course, if the consultant is working at the third-party client side right now, for example, your company has an assignment, because I'm in the DC area, it's easy for me to tell. If your consultant has any assignment with any federal government department, like Department of Labor or anything like that, basically that information is provided already to the client in the LCA, because LCA requires you to provide if the beneficiary is going to work at the third-party client side, that information, third-party client side, the client name, client address, and everything over there. And the same thing you're going to provide in your employer statement, which is basically the statement in general basically constitutes where you discuss about the nature of your business and the job for which what you're offering to the employee, and the job requirements also, and the beneficiary qualifications basically, and how the beneficiary qualifies for the position, everything, and terms and conditions of your employment. Basically, you summarize terms and conditions of your employment over there. Okay. So that will suffice. And also, if you have any written agreement or written contract between you and your employee, provide that one also, basically. If you do not have a written agreement, if it's an oral agreement, the summary of the terms and conditions which is stated in the employer statement will suffice the requirement. Or you can provide a separate statement for summary of the terms and conditions of employment also. These documents, along with the other documents required, that means beneficiary qualifications, beneficiary passport pages, and the I-120 and I-129 supplements, if you file all those things together, and if this information meets the requirements under the preponderance of the evidence standard, that your employer is actually responsible for any one of the factors, hiring, paying, or firing, supervising, otherwise controlling the work of the beneficiary, then USCIS should approve that H1B petition. Okay. So
Bhanu, let's get on to the different rapid fire questions type, so that, in the interest of time, we have 30 minutes and we'll have as many questions as possible on the 15 minutes, and then we will allow the audience to talk. So my first question to you will be the cap cases, right? So how does this affect to the cap cases? Is it a good news or bad news?
It's a good news.
It is a good news.
It's absolutely good news. Yeah, because it's a good, I'll tell you why it's a good news, basically, because see, as I said, there's a good and bad in everything, basically, right? Good is, yes, now that standard is, you can easily prove your employer, basically, right now. Bad news is basically there are two things happens. There are two bad things. One is there is a potential for abuse of the system, right? Anytime. See, Justice Kalia actually very famously quoted that once, basically, I still remember because that is one of the quotes I used in my paper when I was writing my 80-page paper for my LLM program, basically, right? And the quote is basically is that contracts are meant to breach, okay? and so, I mean, basically, there is no need for you to write a contract unless you know that it's not going to get breached, basically, because the trust factor is there, basically, because when you're dealing with human being, it's likely that you cannot rely on their words, basically. That's why you write contracts and writing, so that you force the other person to bind with it, basically, right? Perfect. So when you have these things, any system, basically, it's always meant to abuse, basically. So there could be possibility of abusing the system, basically, right? Yeah. By certain people. And second thing is basically, which I anticipate is there will be definitely proportionate increase in the FDNS site verifications, basically. The reason why the FDNS site verifications is because now this memo is actually preemptively allowing USCIS to avoid H1B approvals where they think or where they suspect that there's some issue of fraud or misrepresentation, basically. Although these memos are not in accordance with the laws, that is what it's actually doing for them. Now, they can't do that. Basically, now they have to approve if you meet any one of the criteria. And meeting either hiring and paying is very easy because as an employer, you are the one who's actually hiring him and you are the one who's actually paying him. And if you can establish that with your payroll tax returns and everything, they should be able to approve your case, basically, right? So they can't really deny your case if you provide the information. They have to take it on the face value of the information what you provide in the petition. And based upon your nature of the business, nature of your petitions you filed in the past and everything, looking into that, then they have to rely on the information what you provide, and they have to approve your case, basically. And they will approve your case based upon that factors and everything. But they have to verify whether this is truthful or not. Then they have to do the FDNS verification. Excellent. So I think that is going to proportionately increase. Maybe we'll have a proposal increasing the anti-fraud fee by the USCIS to the Congress, and Congress approving that, basically. We do not know that yet, basically. Okay. There is a possibility on that.
Perfect, Bhanu. So second thing, right now, due to the COVID, I know that the cap cases should, by now, at least by October, it will be in action, right? So due to this COVID situation, do you have any idea where the consulates are open out of the country?
See, basically, we do not know that yet. I mean, basically, the administration has not given any notification when they're going to open the consulates yet. Basically.
Okay, perfect.
And for the visa services, basically, what I mean is consulates are open for US citizens. They're doing all other work, so like a passport providing and everything for the US citizens, basically. But for the visa services, I do not know when they're going to open. I was hoping that we'll get some kind of a notification in the July first week. But now, because the COVID-19, I think the cases have been increasing again with the opening phases. Basically, we've seen there's a surge in the COVID-19 cases after the opening of many states opening up and everything. And also political pressure on the current administration due to the elections coming up. I do not know how they're going to act on this, basically, because we are hearing more negative news for the people who are abroad to get a visas and everything rather than positive news as of now, basically, from various medias and everything, Okay. And that's one thing which I would like to, I'm a little bit more concerned on this, basically.
Okay. So the next question is, how about the pay, right? So out after 2018, you saw that there should be a minimum pay for the role, what they are doing. So still that continues, or there is any relaxation on that?
No, there is no relaxation. Everybody, I mean, employer has to pay either prevailing wages or the offered wages in the H1B petition, whichever is higher. That obligation is always there. That is pursuant to the Department of Labor Regulations, 20 CFR 735 and 755, all basically 720 from those particular chapters in the 20 CFR, basically, right? And employer is required to meet those requirements if they have to have an H1B petition, H1B employee. They cannot avoid that. And unfortunately, USCIS has not given any relaxation for those requirements to be met during these COVID-19 regulations as well. Basically.
Okay. So keeping in view all this, so filing green cards, what is the situation of the green cards? Do we need to file the existing, for any employer to file green card is a good news, or, is there anything we need to consider?
There's nothing to do with the green cards with this particular memos, because this memo is never applicable to the green cards. These memos are applicable only for the adjudication of H1B petitions, basically. So green card process continues same as is right now.
So due to the unemployment increasing day by day, so do you sense anything on the green cards backlogs kind of?
Maybe you get more audits. There could be increase in the audits of the perm cases, basically. Because you test the labor market, right? Basically, that's how you can do the green cards. Basically, you have to test the labor market to find a qualified US worker by the recruitment process, which is basically prescribed by the Department of Labor. When you test the labor market, it depends upon how reactive, you receive the resumes based upon that. If you find a qualified US worker, then obviously you cannot avoid making the offer to the US worker for that position, basically. But if you do not, then you are still eligible to file perm application and along with I-140 and 485 for your employees. So we are basically filing green cards normally because we did the recruitment properly. Everything is there. If the employees do not get the resumes, or if they receive the resumes also, if the employees doesn't qualify, we basically document that and everything in our law firm. And then we are filing labors. Of course, we are seeing audits coming in. That's expected, basically. But getting an audit doesn't mean that it's the end of the road, basically.
Okay.
So and probably we may see some supervised recruitments coming in, especially when they doubt anything like that. I'm not worried about even that situation also, basically, because I think still there is a shortage for the, especially to put it in a way, majority of our clients are in the IT industry and in healthcare industry, basically. And in these industries, basically, there is a shortage of workers. In both industries, there's a tremendous shortage of workers, basically, and qualified workers, basically. That's very, very important. I mean, everybody who applies for it may not qualify for it, basically, may not be able to do it competently, that job, basically, as required for that particular position to be done. They may not have enough knowledge or a specificities of abilities to basically do that, basically. So I'm not worried about those things, basically, because those things are part of the process which we will be able to maybe delay. It may delay adjudications, basically, a month or two. Approval dates may increase month or two, but in the end, I don't see any major issue, basically. Okay. And only thing I see with the perm cases coming into effect is that now how the benching will be documented by the employers, basically. Right now, there's nothing to monitor benching of the employers right now, basically, right?
Okay.
Statute, basically, that benching, how it's going to affect the green card is what really worries me, basically, right? For example, I will tell you one small example why I think that is very, very important here, basically, because, see, anytime unpaid benching is completely prohibited by law. I mean, statute clearly prohibits unpaid benching because it worries about the involuntary servitude, bonded labor, and also affecting the wages of the US workers, basically, right? Therefore, unpaid benching is completely prohibited by law. Statute prohibits it. There are certain exceptions to the unpaid benching, basically, by the statute. And those exceptions are basically if somebody is basically for medical reasons or any other personal reasons take a voluntary leave of absence, that voluntary leave of absence period can be unpaid by statute. Okay. And it's a very common thing we see that a lot of employees basically take a leave for the maternity purposes, especially if the wife is pregnant or anything, they take a break and they will not work for 2-3 months because somebody has to take care of the family, basically, or basically if somebody wants to go on a training, basically, right? Somebody wants to increase their skills or anything like that, and employer cannot afford that training. It cannot be part of the job, on the job training, basically, right? If it is on the job training, that is where the issue with the perm cases will come, basically, right?
Yeah.
Because if you allow your employees to acquire on the job training, then the US worker, whoever is applying for the job, should be eligible to get that on the job training. Therefore, you should not be denied the job offer. Okay. So how employer is going to document that? If it's the job training voluntarily by the employee or by the employer, basically, sometimes employer will have a bench in between. Basically, for example, between the transition of the assignments, right? One assignment to another assignment, basically, there will be some period of time. There is statute never disclosed or even regulations never defined what is a reasonable period of time between between the transition of the assignments, basically, right? Whether it's a 1 month, whether it's 15 days, whether it's 10 days, it has not been basically disclosed, right? See, other day, one of the friend of mine asked me a question, basically, friend of mine or client of mine, or basically colleague of mine, whatever you call it, asked me a question, basically, what if I basically paying him the wages at the time when he was on a bench, and he's basically also getting a training at the same time? And can I basically say that because of the training, I was not able to place him in another assignment? You know, he is paid so that his employee, so that the employer is in compliance with the Department of Labor regulations. And whether does it still constitute a material change in the job? Basically, does it require filing an amendment to the H1B petition, or basically he's out of status otherwise? Basically, right? I said basically there are two factors which you have to look into here. Is basically is one, how it's going to impact your perm applications. Basically, if you're filing for the same position where it is okay, where you're providing on-the-job training, why can't you provide that to the US workers? Basically, okay, and basically that is one thing which you have to look into. That basically. Second thing is basically is that how long the training is. Is it reasonable for an individual to have the training in order for him to successfully perform the job for the clients or for your business, basically? And how do you document? You have to document that these things have to properly laid down in your employee handbook. Basically, you have to really publish this material somewhere to document that, so that if somebody comes in, you can actually establish that this is actually the practice which you go through in your company, basically.
Okay.
Right?
I don't think it will happen.
These things will happen. Basically, these things are going to happen. So there's a reasonable period of time. So basically, in the past, when I did the Department of Labor audits, basically when there's a 1 month gap or anything like that, if the employee actually paid the money in that bench period, I was successfully able to show that that's during the transition period from one assignment to another assignment, because he has to move his family, he has to move everything from this assignment to this assignment. That's where it's been taken, and we file amendment timely, also properly, also, and we basically shown that basically,
Okay.
And when we did that, Department of Labor did not hold the employer responsible for that 1 month period, or for the back wages, or in violation of the regulations or anything like that.
Yeah.
And basically, sometimes I can see the time for this assignments can go beyond the 1 month also. For example, certain placements, certain project assignments requires you to complete or get certain background clearances done, certain security checks to be done, And the employee may not have the security checks in the beginning, but that particular client for that position, you need to have certain enhanced security checks to be gone. And sometimes those background checks, those security checks can go beyond normal time, right? 2 weeks transition period or 3 weeks transition period. Sometimes it can go 6 weeks, 8 weeks, 10 weeks, basically, right? And if that is the case, he cannot go and work at the client side. Although you're willing to file an H1B petition, over there, client is not basically conforming to you and has not given the affirmative go for you to get the assignment for the consultant, because they're waiting for this background checks to be completed, right?
But Bhanu, how do we track this? For example, let's say the customer has given a notice to him, and the employer of this candidate will give he will pay his pay, and during this 2 or 6 weeks he can get either he can get screened or he can get trainings. How do the USCIS know about this? Until and unless if you file an LCA, you don't file an LCA.
There are two possibilities, right? One is FDNS verification.
Okay.
And second thing is, if the Department of Labor if the Department of Labor spontaneously decides to audit your company.
Okay.
Or if somebody files a complaint against your company and Department of Labor taken that complaint and they came to audit your company, basically.
Okay.
And if those things happen, basically, then obviously the USCIS can come to existing to that. And you file an LCA also, basically, right? When you file an LCA, you have to file an amendment on or before consultant joining the location, basically, right?
Okay.
So there are various factors.
I think more interesting questions from people are like, for example, in between you are laid off, you are furloughed, you are getting a severance of 6 weeks. So in that case, I wanted to ask you 2 questions. What is the, if any person is laid off, what is the duration he can retain his status? 60 days or 180 days? That is the first question. Second question, for example, if an employee is given a severance of 6 weeks, so his period of status will be 6 weeks plus 60 or 180 days, or only it falls into 60 or 180 days?
See, severance payment has nothing to do with its last date of employment, basically.
Okay.
The employer actually paying you severance because your employment is ended with him on a particular date. Okay. The individual may be eligible only for 60-day grace period. Okay. That means is authorized to stay for 60 days in this country, either to find an alternative job, or basically to file for a transfer, or basically to file for a change of status to some other valid status if he has a possibility getting into some other status, or to depart this country, provided that his H1B validity period is more than that 60 days, basically, with that company. Okay. And second thing is basically he has not used the 60-day grace period anytime during that validity period of that H1B petition. Okay. And if that is a possibility, then he may be eligible only for 60-day grace period. 180-day period is basically it's basically false. That is basically there's nothing there. Okay. See, 180-day rule, what it says is basically is that if you're out of status in this country more than at least 180 days, then if you depart this country, you will have a 3-year bar to apply for a visa abroad, basically. Okay. If you overstay even 1 day in this country, you have to stay in all your future petitions that you overstayed in the United States, basically.
Okay. That's interesting.
Yeah.
Are there any? Go ahead. Sorry.
I'm sorry, you're saying something, sir.
I was just thinking, in these 60 days, are there any emergency situations where we can extend 1 month or 2 months of the situation to keep our status?
No, unfortunately, no. That's why you have a possibility of filing for a change of status, right, within the 60 days.
Okay.
And if something going wrong in that way, you have an option to file for B1, B2 in this country anytime, right, within the 60-day period. Just file for B1, B2 within the 60-day period, which allows you to stay for 2-3 months more, basically. Okay. And then you can depart the country, right? You have a possibility of filing for B1, B2 to change their status. And I do not know why a lot of people are resistant doing that, because they get a false information from various medias and various places, basically. And its problem is they have too much information available for them. It's very difficult for them to decipher that information, to basically differentiate that information. That is the whole problem here, basically, Exactly. And what I see is, that is the problem I see. Basically, sometimes deciphering information, what they receive is also very, very important, right? And that aspect is actually what really makes it difficult for them, basically,
And in this line, if at all a person is having his B1, and as soon as he gets his job, still his H1 is valid, right? So he can switch back, or again, you need to do something.
He has to file for a change of status. File for a change of status, basically.
Okay.
Okay. And most likely, if his B1 is not approved by that time when he's filed for a change of status, then his change of status may not be approved until B1 change of status is approved. And what basically that H1B may approve for the consular processing, he may have to go abroad, get visa stamped, and then come back. Okay. If he cannot wait until the B1 is approved, basically.
I think with this memo, most of the problems are solved for people, because within the 60 days, they can find something. And now that the client letter, SOWs, MSAs, SLAs are all not required, I think from my perspective, it's a good news. So what do you think, Bhanu?
It is absolutely good news. It's a game changer, I would say, basically, because now we are going back to 2000, prior to 2010. However, you have to understand that is USA still can ask for those things under the Defense versus Meisner case, basically, right? And we still have to comply with the matter of Semio Solutions and its memo, basically, for amendments and everything,
Yeah.
And those cases are still intact, basically. And it's actually relieving one way or another, basically, because we are back to actually reality, to common sense, basically, And in the past, that's how the H1B is supposed to be. The H1B regulations actually intended that, basically. The statute actually intended that, what an employer is supposed to do, basically, This has actually caused too many problems and sometimes too many evils in the society also. Exactly. And it created alternative currency in the form of client letter and everything. We've seen too much abuse in the system and everything also. Previously, only problem is about the benching issue, but there are no any fraudulent acts by the employers, basically. We have seen few, but very few. We have not heard this many cases coming up against the employers that willfully misrepresented or anything like that in the past, basically, right? After this client letters and everything came up, it became so tough, employers became desperate, and that's where the things happened, basically. Now, although they have no intention to commit those things. That's what I strongly believe, you know. And sometimes these kind of things happen. I mean, as I said, every system is meant for abusing, basically, and that's what it is, basically, you know. And but now employers, they actually can do business the way they're supposed to do the business. And I'm very happy that these memos have been rescinded. I'm not saying that USS may not come with some other policy, but this time if they come, they'll be very careful. They have to go through all the 9 steps which is required to comply with the regulations and with the statute to make them enforceable policy, basically.
Okay.
You know.
So another question, Bhanu, prominent question. People right now in crisis, many of them call me and say, "Hey, I have an emergency. So when I go back, everyone says that coming back is a problem. So when you are out of the country, it is very difficult for now to enter into the country
Because
so
of the COVID-19.
Yes.
Because of the COVID-19.
Nothing
I mean,
to do with the visa?
Nothing to do with the visa right now, because it has to do with the COVID-19, basically, you know. And because they don't have flights right now. If they have flights, they should be able to come to US without any problem if they have a valid visa in their passport.
But we also see that people we also heard that once you are out of the country for 90 days will not be allowing. So that might also be a problem when you go out of the country.
No, that is absolutely false news. It's baseless news. There's nothing like that. There's nothing like that saying that if you're outside the country for 90 days, you're not going to be allowed. There is nothing like that. And it's completely false news.
Glad to know. So, Bhanu, another thing, I know that there is an executive order going to come. So there are a lot of speculations in the market that, you know, the price might increase 3 times. So which will be really tough for everyone to file. So that's what hearing. Do you know any insight on this future?
They cannot increase price like that, sir. Basically, they have to go through the policies and procedures, basically. And USC's H1B filing fees are basically determined by the Congress. So Congress has to pass the regulations, basically. President cannot do that by executive order.
Okay.
You know? So I do not know, because that authority is given to the Congress. The purse is always controlled by the Congress, not by the president, basically, not by the executive department. And so I do not know whether that kind of a procedures proposals will come into existence or not. I'm not saying that they won't, but my point is they have to go through all the muster to pass. I don't know how anything to do with the immigration right now. It's a toxic content for the Congress right now. So I do not know what will happen there, basically, you know.
Okay. I think with that said, in the interest of time also, we have 3 to 5 minutes. But again, if you are okay, we can extend 5 to 10 minutes. We have only 11 audience. If anyone have any question, I would let them ask directly to you rather than me taking over. So I will open for them.
Sure.
Guys, in the call, thank you for joining. You all can ask question if you have any. So Bhanu is more than happy to answer this. And if you have any questions, definitely you can email me. I can connect with Bhanu and get you all the information. And you can go on to my site for this recording as well. You can hear that and you can understand what was told. If anyone is missing, this is also live on the Facebook right now. So with that said, please subscribe to Being Social for all these information videos. And over to you all. Anyone have any questions to Bhanu?
Yeah, I have one question actually. This is Satish.
Yeah, go ahead, Satish.
Actually, this is regarding the new the executive order that President Trump is going to sign, and you might have seen a lot of things going on over the media and in newspapers, they're going to take some actions against this H1B and the J1 or any other visas. Yeah. So how it is impacting the one which has already been staying here, and if someone, as Praveen mentioned in one of the point, if for some reason they have to go to India, for any family reasons or anything, and it does mean they have to stay back over there till this some period of time, policy works, policy end date or something like that.
Satish, nobody knows exactly what the memo executive order is going to be, basically, right? It's all speculation. Or what we are basically talking about is basically what people are talking in the media right now. Basically, we do not know exactly what's being written, what's being stated. Actually, whether that memo is going to come out or not, also we do not know that, basically, because we know that anti-immigrant groups say like a fair, and those people are really lobbying to get this memo out, because it is their agenda going against H1B program, irrespective, although they work with the low-skilled immigration program against low-skilled immigrant workers and everything, but their agenda is basically anti-immigration agenda. Basically, those organizations are very close to current administration right now, and they're working on that. And whatever they are saying outside, that's what is coming outside. Basically, we do not know how it's going to basically return, what kind of exceptions they're going to state in the memo, basically, for which kind of a people will be applicable or not. We only know that right now is president has an authority to limit somebody to enter into this country or outside the country. He doesn't have an authority to stop immigration process for the people who are in this country. That is basically statute does not allow him under section 212. Basically, he has a Supreme Court also clearly stated that under insurmountable amount of power, he has unlimited power of authority whom to enter into this country, whom not to enter into this country, basically, right? So we do not know whether he's going to put exceptions to the people who are already in this country and have a valid visa in this country will be able to come back into this country or not, or is going to restrict only for the people who are actually applying for new visas abroad for 6 months. People are expecting that it's going to be till end of the year, till December, basically, because if he does that, he's going to basically keep his base happy, basically. Okay, and that's what it is all meant for. Nothing but it's completely political in nature rather than any economical reasons or any other COVID-19 concerns or anything like that, basically, you know. And we have to see all those things, Satish, because it's very difficult for me to tell. And yesterday in npr.org, basically, and FAIR, everybody made a statement saying that the memo is coming yesterday, executive order is coming yesterday, basically, right? And I know that it's basically they're hitting on their foot, basically, because that is not true, because we still hear that still it's in writing, still so many things are going on there, so much lobbying is going on there, basically, you know. It's going to impact so many Fortune 500 companies. Do you think they won't be lobbying on this bill, on this executive order? I think something is basically not adding up here, how fast this executive order will come into existence. I'm not saying that it cannot come tomorrow, because we are seeing a president who is basically very, very erratic or very eccentric, basically, right? So we don't know that will happen or not, but point is, our president is basically, we know where he stands as far as his immigration policy is concerned. That's the right way to say, rather than eccentric and erratic, basically, because everybody has their own agenda. Every party has their own agenda in immigration, basically, how to present their particular policies in front, basically, for their particular constituents, basically, right? And that's what it is, basically. So Satish, let us wait before coming to any conclusions or any assumptions, basically, what's going to be in the executive order, basically. You know, right now, people who have a visa abroad, they're able to come to US. Now, I don't think there is any restrictions on that. I can basically think that that is what is going to happen. Basically, that's what he said in the past also, basically, right? When he basically put the restrictions on the immigrants coming into this country. He basically said that existing LPRs can come, travel, there's no restrictions. Only new LPRs are the ones who cannot come for 60 days. And that is also ending this month on June 22nd, basically, right? That is by tomorrow. I think tomorrow, actually, it's ending. So that's what it is, basically. Okay.
Oh, thank you.
Yeah, sure.
Any other questions? I think that's all.
I think, yeah.
Any other thing you want to tell Bhanu before we close as a closing notes?
No, nothing. I would say that basically, yes, just go ahead, do your business normally as an employer. And now it's a good thing. You are actually, I would say that do not submit unnecessarily information what is not required to get an H1B approval. Submit under the preponderance of the evidence standard whatever information is required to get an H1B approval. The minimal information, that is enough. You do not have to document unnecessarily exhaustively to get H1B approval, because you may be calling for yourself in trouble if that information is not really required. You know, just provide as required information as advised for this memorandum to establish employer-employer relationship, establish specialty occupation, and other requirements that is warranted for the H1B approvals.
Thank you so much, Bhanu. I think we all are very thankful for your 1 hour of your time, valuable time, that too weekend, and all these efforts. Really, again, thankful to you. And all this effort is only to help the community know better. I know that many people cannot reach the attorney so easily. I just thought being a part of media, being a part of community, I just wanted to give this information to anyone. And if anyone sends me an email, definitely I'll reach out to you and get them clarified. That's all the interest. Again, great insights to this. Thank you so much. Have a great weekend. And who are on the call, please subscribe Being Social. So this video will be there, and many more videos you will be finding, only informative videos. So thank you so much. Stay tuned. Bye.
Thank you. Thank you all. God bless you all. Stay safe, stay healthy. Please follow social distancing policies strictly. Still, we haven't seen any relief from the COVID-19. All of you, please take care of yourself. And if any one of you are fathers, please have a wonderful, happy Father's Day, and enjoy the day.
That's true. Happy Father's Day to you. Thank you all.
Thank you. Yeah, bye.